Hello friends, I'm Sanjay. In this series, I'm solving and explaining the CLAT PG 2024 question paper from the exam that was conducted in December 2023. This is part 5 of the series and I will cover the 5th passage and the 5 MCQs associated with it. You should watch this series from part 1 onwards, in which I have given a brief overview of how to tackle this paper. The 5th passage is based on a 2022 judgment by the International Court of Justice or the ICJ on an application filed by the Gambia against Myanmar. Given that very few students would have read the source judgment for this passage and fewer still would remember the details, the questions for this passage would have to be answered using the information within the passage, or by analyzing the answer options, or through your external legal and general knowledge, or through guesswork. So do not worry if you find these 5 questions to be a little difficult or confusing. With enough practice, you will become better at tackling passages and questions like this. There is a common sense trick to answering questions related to passages like this. And you will see that this approach works for at least 4 out of the 5 questions here. What is the central topic for this passage? It is essentially a crime against humanity, even if it is related to some disputes between 2 or more specific countries. And what does our common sense tell us? When it is a crime against humanity, every human, and by extension every country, will have a right to approach the ICJ or the UN to try and mitigate the situation. It might not give the right to a country to try and intervene by itself, but any country can definitely approach the ICJ or the UN. Which means that no treaty and no agreement can prevent a country from asking the ICJ or the UN to intervene in situations where it feels that there is a crime against humanity. And the key element in this passage is that the Gambia is asking the ICJ to intervene, and Myanmar is arguing that the Gambia does not have any locus standi to bring up the issue with the ICJ or the UN. When we apply our common sense conclusion, we can say that Myanmar cannot prevent the Gambia from approaching the ICJ or the UN. Use this logic while answering the questions, and you will be able to choose the correct answer, or at least eliminate some of the incorrect options and guess from among the remaining options. And one more thing, typically the names of countries don't start with the. We say India and not the India. But here the name of the country is actually the Gambia. So it is not a grammatical error. Question 21 is talking about a hypothetical situation and asking us to identify what type of jurisdiction is being used in the situation. This is a tricky question because this is not referring to the jurisdiction used by the Gambia in this case. But what is the kind of jurisdiction that a country can use in the situation described in the question? This is an external question that can be answered if you have an idea about the different kinds of jurisdictions a country can have in the context of international law. You can also use the common sense approach to identify the correct answer. Since the reference here is towards crimes against humanity, every country will have the moral right and the universal jurisdiction to take action or to approach international bodies. The correct answer here is universal jurisdiction. You can pause the video here and read about what are universal, extraterrestrial and contentious jurisdictions. Question 22 is asking about the meaning of the Latin phrase erga omnes partes. The passage mentions the term here, but does not elaborate on its meaning, definition or explanation of the term. So this is an external question. The correct answer here is option A. When a country enters into a treaty, there are some aspects of the treaty that are at its very core, and there can be no reservations or derogations on any obligations related to these aspects. For example, if India, France and Germany sign a treaty to tax-free exports of sugar between themselves, that is the core objective of the treaty, and none of the countries can have any reservations or derogations on these core tax-free exports of sugar. Otherwise, what is the point in signing the treaty in the first place? Of course, there can be some exceptions or conditions written into the treaty, but if these exceptions or conditions were not written upfront, countries will have to deliver on what they have signed up for. Question 23 is asking whether Article 44A of the ILC's articles on responsibility of states for internationally wrongful acts prevents the Gambia from invoking the principles of state responsibility against Myanmar. The answer here is option C, because again this is a crime against humanity and not merely an internationally wrongful act. So yes, the Gambia can invoke the principles of state responsibility against Myanmar. Here again, we have used the common sense approach to say that every country has a right to approach the ICJ in such situations. Question 24 is a direct question because the information required to answer the question is given in the question itself. Let us look at what Article 9 actually says. It says that disputes between contracting parties to the convention relating to the interpretation, application or fulfillment of the convention, including those acts listed under Article 3, can be submitted to the ICJ by any of the parties to the dispute. So here Gambia is a party to the convention. It is claiming to be a party to the dispute since this is a case of a crime against humanity, even though this particular crime is not affecting its own citizens. And Article 9 says that disputes about interpretation, application or fulfillment of the convention can be submitted, which covers almost everything about the convention. So the Gambia can submit its case against Myanmar, even though it is a non-injured party, which means that Myanmar's claim is not maintainable. The fact that Bangladesh is precluded from bringing a case or that Gambia is a non-injured state does not affect the Gambia's locus standi because it is still a party to the convention and has its own rights. Here again, the common sense approach will help us in identifying the correct answer. If it is a crime against humanity, the Gambia can definitely seek the ICJ's intervention. In question 25, Myanmar is claiming that the ICJ and the UN cannot intervene in the situation. Again here, our common sense understanding says that ICJ and the UN can intervene in situations involving crimes against humanity. Therefore, Myanmar's claims are not maintainable. This eliminates options A and C. With the two remaining options, we already have a 50% probability of selecting the correct answer. In the question itself, it is written that the ICJ is the principal organ of the UN, which means that the statement in option D, that the ICJ is not regulated by the UN Charter, is incorrect. So the only option that is left is option B, which is the correct answer. In the next part, I will cover passage 6 and the associated questions. I would recommend that you should read the passage, the source, and also attempt the 5 questions on your own, and you'll be able to follow the explanations more easily. You can also go to lawmen.com and check out the CLAT PG mock test series for the next exam, which includes all CLAT PG previous papers, including this one, and both new and old pattern mock tests for CLAT PG and other LLM entrance preparation. You can attempt a free full-length mock test to get a feel of the series. I will see you soon in the next video. Jai Hind.